Right-wing Supreme Court Justice Clarence Thomas has a new nemesis on the Supreme Court. It's Justice Amy Coney Barrett. Yeah, she's becoming a nemesis to the MAGA world. Let's discuss. I'm Dave Aronberg, State Attorney for Palm Beach County, a.k.a. the Florida Lawman here on the MeidasTouch Network. I know what you're thinking. Amy Coney Barrett, one of the right-wing justices appointed by Donald Trump, who then went on to overturn 50-plus years of precedent in Roe versus Wade. Yeah, she was one of the votes to overturn Roe versus Wade. It was a 5-4 opinion. Chief Justice Roberts actually voted with the liberals on the court. Those Supreme Court justices, including Amy Coney Barrett, who said during their confirmation hearings before the Senate that Roe versus Wade was settled law and then went ahead and unsettled it. Yeah, well, it looks like that Amy Coney Barrett has decided that she doesn't want to be part of that group anymore. And that's a major development because now, if Kamala Harris becomes president, she can dramatically change the Supreme Court, whereas people thought it was a 6-3 conservative majority. This is going to take generations to fix. No, this could happen a lot faster because it looks like Amy Coney Barrett is following in the tradition of other Republican-appointed Supreme Court justices who turned out not to be as conservative as once thought. Justice Harry Blackmun, appointed by Richard Nixon, ended up writing the Roe versus Wade opinion, the majority opinion. Then you had others like Justice Souter and Justice Brennan, all appointed by Republicans. In fact, Eisenhower said, "I made 2 mistakes, and both of them are sitting on the Supreme Court." And he was referring to Chief Justice Warren and Justice William Brennan, who became one of the great liberals on the court in the court's history, opposing the death penalty and championing women's rights and supporting the legalization of abortion. So yes, those justices were appointed by Republicans. And although I'm not giving Justice Barrett a pass on her decision in the Dobbs case, but what's happened since the Dobbs decision is notable. She has made a series of decisions that not only has sided with the liberals, but has really tweaked Justice Clarence Thomas, the most right-wing of all the justices, the hero to the MAGA right. In a decision that has turned some heads, the U.S. Supreme Court decided to keep in place at least part of an Arizona law that was passed after President Biden won Arizona in 2020 by 10,457 votes. And by a 5-4 margin, the Supreme Court partially approved the requests by the RNC that would make people in Arizona show proof of U.S. citizenship when registering to vote. But look who voted with the liberal justices. Conservative Justice Amy Coney Barrett voted against the measure and sided with the liberal justices. In 2022, Arizona's GOP-controlled legislature passed a new law that bans registered voters who have not provided proof of their citizenship from voting in presidential elections or by mail for any federal office, like U.S. Senate. The U.S. Justice Department and civil rights organizations led by Mi Familia Vota sued, and following a 10-day trial, U.S. District Judge Susan Bolton struck down that restriction after finding that it is preempted by the National Voter Registration Act, which Congress passed in 1993 to make the registration process easier for eligible voters. Bolton's decision cited a 1976 Supreme Court decision that said the High Court has recognized broad congressional power to legislate in connection with the elections of the president and vice president. The Republican National Committee, along with Arizona's top GOP state lawmakers, appealed Bolton's ruling to the Ninth Circuit Court of Appeals. The Republican National Committee had asked the court to put a pause on the lower court ruling against the 2022 law. And in a 5-4 decision, the High Court granted part of that request, allowing Arizona to enforce, for now, a section that requires election officials to reject state voter registration forms that are submitted without an applicant's proof of U.S. citizenship. That provision will remain in effect as an appeal proceeds. And the MAGA world has been melting down over it. Quote, "What the hell is wrong with Amy Coney Barrett? She voted with the liberals on the court to block a requirement for proof of citizenship in Arizona to vote. She's a disaster," wrote Bill Mitchell, the host of Your Voice America, on Twitter. And no, I'm not going to call it by its other name. And then, of course, you've got to look at Cat Turd, who wrote, Amy Coney Barrett strikes again. Yes, thank you, cat turd, Bill Mitchell and the MAGA world for giving us all a little extra bounce in our step. In the Rahimi case, you remember that one? That's the one that involved whether or not someone under a civil restraining order for domestic violence could own a gun, and Clarence Thomas was the only vote in the dissent within that Supreme Court to say, yes, you still have a right to own a gun even if you're under a domestic violence restraining order. And according to Newsweek, during oral arguments, Thomas asked Rahimi's lawyer why a criminal defendant should be subject to a civil remedy like a restraining order. Justice Coney Barrett, though, immediately pulled out a copy of the restraining order which forbids Rahimi from coming near his now ex-girlfriend or her daughter. She then read from the restraining order's list of Rahimi's alleged crimes against his ex-girlfriend, including threats and intimidation. By doing so, Coney Barrett was signaling that she does not agree with Thomas's strict constructionist view of the Second Amendment. Thomas's school of thought suggests that readers should look only at the wording of the Constitution, which placed no impediments on the rights of U.S. citizens to own a gun. Also, there was this trademark case, which Coney Barrett and Thomas ended up on the same side along with the rest of the court, which was about the registration of a phrase called Trump too small for use on merchandise. The details of this case are unimportant. It was a unanimous decision. In her decision, she made a point of sticking it to Thomas because Thomas wrote the majority ruling. And she said in a concurring opinion that Justice Thomas mistakenly suggests that I present the Federal Trademark Register as a limited public forum. That is not my position. Justice Thomas ignores my reasons for drawing the analogy. So I know that doesn't sound like it's a real zinger, but when a Supreme Court justice says that a fellow Supreme Court justice is misrepresenting her, is putting out something that's not true about her, yeah, that's big news. That's actually something, especially when you're supposed to be on the same right-wing team. And that shows you that there is a simmering dispute between these two. And she, Amy Coney Barrett, is not afraid to let it get out into the public. She's giving public speeches now saying that we should not base our judicial philosophy on the philosophy of Clarence Thomas and his acolytes on the court. Because remember, they are on a strict constructionist viewpoint. It's looking at history. And if history it does not show that there was a right to an abortion, then there is no right to an abortion. Well, yeah, if you're going to look back at the 19th century to determine whether women had a right to an abortion, you are cooking the books. You are intentionally deciding upon a time period where the answer is going to go your way because women didn't have rights back then. You're going to look to the 18th century, 19th century to decide what we're going to do today on women's rights, saying, well, there's no history of abortion rights. There's no history of birth control pills or gay marriage. Well, then you know what you're going to do. You are intentionally looking at that part of history to come out with your desired outcome. You are intentionally picking a part of history where they're going to rule your way. It's not like some objective, well, let's see what they said back then. No, you chose that time period for a reason because back then women didn't have rights. There was no understanding of same-sex marriage or birth control pills. And Amy Coney Barrett gave a speech last year at Catholic University where she said, according to Politico, that we have to be very, very careful in the way that we use history, she said, adding that deploying historical evidence to advance a legal conclusion can be like looking over a crowd and picking out your friends. Yes, exactly. If you're just going to look at history and practice, tradition, to decide the rights of women in the year 2024, it's like, all right, asking just your friends to tell you that you're right. I mean, that's the kind of thing that Clarence Thomas is used to when it comes to his jurisprudence. And Amy Coney Barrett has had enough of it. Let's look at her recent ruling in the most controversial opinion of this year, and that is the immunity decision, the one where it was a 6-3 Republican majority, including Amy Coney Barrett, who went along with the Republicans to say that there is presidential immunity, this broad immunity, but she stopped short of the worst part of the ruling. She didn't go along with the Republicans. She went along with the liberals on the court, saying that this one section that prevents the use of evidence of official acts to prove a crime, that was going too far. She actually said that we should have a trial of Donald Trump now, that the Supreme Court should not be just saying, well, let's send this all back to Judge Chutkan to decide whether there should be a trial of Donald Trump. She said there are clear things that Trump should be on trial for that are clear unofficial acts. In her concurring opinion, she said some of those allegations raise unsettled questions about the scope of Article 2 power, but others do not. For example, the indictment alleges that the president asked the Arizona House Speaker to call the legislature into session to hold a hearing about election fraud claims. The president has no authority over state legislatures or their leadership, so it is hard to see how prosecuting him for crimes committed when dealing with the Arizona House Speaker would unconstitutionally intrude on executive power. And in a footnote, she said, sorting private from official conduct sometimes will be difficult, but not always. Take the president's alleged attempt to organize alternative slates of electors. In my view, that conduct is private and therefore not entitled to protection. The Constitution vests power to appoint presidential electors in the states. And while Congress has a limited role in that process, the president has none. In short, a president has no legal authority and thus no official capacity to influence how the states appoint their electors. I see no plausible argument for barring prosecution of that alleged conduct. So she's saying that it should be game on, that in D.C. they could go ahead right now and prosecute at least some of these charges, but the majority of the Supreme Court was against her. And as I said previously, she also believes you can use evidence within official acts to prove a crime involving an unofficial act. So she is someone, I think, as you can see, bit by bit, decision by decision, is moving towards the center because she seems to be siding a lot more with the liberal justices than with her supposedly conservative peers. Something to keep a watch on, especially if Kamala Harris becomes president and gets to appoint a Supreme Court justice. That 6-3 conservative majority may not be 6-3 after all. It could be 5-4 with Chief Justice Roberts as the swing vote again, and then one justice, a Clarence Thomas retiring, an Alito retiring. That's enough to possibly swing the court. So there is hope after all, Midas Mighty. I'm not saying that we should be standing up and applauding Justice Barrett because her decision in the Dobbs case was, as I said, I think wrong, and I think that it's still troubling to me. But what she's done since then has shown that she is becoming more independent-minded. She is someone who has been battling against Clarence Thomas, and when you're Clarence Thomas's opponent, sounds decent to me. What do they say? The enemy of my enemy is my friend. Wouldn't call her a friend yet, but at least it seems like she's moving in the right direction. So something to keep a watchful eye on, Midas Mighty, and we'll do it here on the MeidasTouch Network. I'm Dave Aronberg, aka the Florida Lawman. If you like this video, please leave a comment below and share with a friend. Also, check out our sister channel, True Crime MTN, where I do a lot of videos and other contributors on true crime cases that don't make it onto the main MeidasTouch network. Check us out over there, and I'll see you also over here next time.
Love this video? Make sure you stay up to date on the latest breaking news and all things Midas by signing up to the MeidasTouch newsletter at MeidasTouch.com/newsletter.